Welcome to Legally Green, the podcast on sustainability's formative effects on law. Welcome again to Legally Green, where we explore the environmental issues that are shaping the law of the future. My name is Robert, and as always, I'm joined by Zuzana.
Hello.
And by Hanna.
Hello.
Yes, and we are delighted to be back after quite a long break to bring you the latest developments in environmental law. And since you haven't heard from us for a while, maybe let us briefly recap the last few episodes first, so you know where we are.
We have already discussed some of the fundamental issues of nature rights. For example, the definitions of nature and the environment from legal and philosophical perspectives through questions such as whether nature should be considered a subject or an object of law, whether humans have a right to the environment or the clean environment, or whether non-living elements of nature can have rights, just like sometimes we say animals have rights.
We also delve into more substantive developments and debates by taking a closer look at the regulation of sustainable finance, including ESG considerations. Finally, in our last episode, we took a look at one of the most polluting industries, that is the transport sector, and we covered road, air, and maritime transport.
Yes, and in today's episode, we are not looking at philosophical or purely substantive matters, but today we are going to look more on the enforceability of environmental protection at EU level specifically, with a particular focus on access to justice in environmental matters and the protection of the environment through criminal law.
As we discussed previously, the importance of environmental protection cannot be overstated with the growing threats of climate change, pollution, and the decrease in biodiversity. Robust mechanisms for enforcing environmental laws are absolutely crucial. But how effective are these mechanisms, and what role do legal frameworks specifically play in ensuring environmental justice? That's the question.
Yes, and that's why today we will look at the European Union's approach to environmental protection. We will discuss how access to justice empowers citizens and organizations to hold polluters to account. And we also look at the role of criminal law in deterring and punishing environmental crime. So we'll start by looking at what access to justice in environmental matters means and why it is vital for the enforcement of environmental laws. So that's where we'll look at the Aarhus Convention, which is implemented within the EU legal framework, which gives basically the public the right to access information, also participate in decision-making processes, but also what interests us the most, seek justice in environmental matters. Then we'll shift our focus to environmental criminal law, when we'll look at how the EU tackles environmental crime through legislation such as the Environmental Crime Directive. And from illegal waste disposal to wildlife trafficking, we'll discuss the types of offenses covered and the challenges of prosecuting these crimes. And finally, we are going to connect the dots between access to justice and law enforcement. So how do these two aspects of the legal system work together to protect our environment? And what can be done to overcome the challenges and improve the effectiveness of these laws?
Whether you're an environmental lawyer, a legal professional, or simply someone interested in the mechanisms that protect our planet, this episode will provide you with valuable insights and a deeper understanding of how environmental laws are enforced in the EU.
Yes, so stay with us as we embark on this journey into the heart of environmental justice and criminal law in the European Union. And, well, I think it's the time to start.
So, Robert, could you explain what is access to justice and what exactly does it mean in the environmental context?
Well, okay, so access to justice in environmental matters is basically it's a cornerstone of environmental protection. It ensures that citizens and organizations can actively participate in environmental governance, but also hold violators of such laws accountable. But what exactly do we mean by access to environmental justice? Well, simply put, it refers to the ability of individuals and groups to seek legal redress when environmental laws are violated.
But as we discussed in our first episode, the material right of the individual is too narrow to encompass the protection of the environment as a whole and the common good. Not only because individuals might not even be aware of a certain impact or be impacted by the environmental issues to an extent insufficient to allow them to bring a claim, but also that even when they are aware and impacted, legal systems nowadays pose obstacles for individuals to bring claims for damages caused on non-individual level, such as climate change. And the most easy example in the European Union would be the Plowman criterion for individuals to bring a claim.
Yes, well, exactly. And hence the question, who should control action in this regard, right? So who else should be the subject of rights to make it possible to protect the environment beyond individual damage? And also, as we touched upon this aspect in our first episode, Professor Stone's "Should Trees Have Standing" poses a problem that, as we discussed, is practically impossible to solve in the current system.
Yes, exactly. Even for that system of nature protection to be effective, we need to be able to act in not only the private interest, but also the public interest. Of course, not everyone, but in particular, the environmental and social organizations should have more possibilities to appear before courts, even when traditional tort law fails to provide them with an opportunity to do so.
Exactly, and that's why it has been recognized by legislators as early as in 1972, with firstly the Stockholm Declaration, and later in 1992 with the Rio Declaration. However, the most notable development that has been created in this regard is the Aarhus Convention, which I already mentioned, which entered into force in 2001. And this convention created a so-called three-pillar structure for access to justice in environmental matters. So basically, these include the right to access to information, the right to participate in decision-making, and the right to challenge public decisions that have not been taken in accordance with environmental law or principles. And from the European Union perspective, it also established quite a robust legal framework to support these rights, even before the Aarhus Convention, with Access to Information Directive, or EIA Directive. This framework, however, regulated only the access to information and participation of the public in decision-making process, but not access to justice, right, which is this Aarhus Convention main element. And only through the Aarhus regulation, which implemented Aarhus Convention to our EU regulatory framework, the EU fully incorporated the all three pillars mentioned above, right? So basically the convention was created precisely for the reasons we mentioned in our first episode, namely that traditional legal instruments do not guarantee effective protection of either individual or public interests in the field of environmental protection.
Could you break down the three pillars for us? How do they differ from one another?
Yes. Okay. So first we have access to information. Basically, it ensures that the public can obtain environmental information held by public authorities. It's basically about transparency, allowing people to know what's happening in their environment and how decisions are being made. Individuals and organizations have basically the right to request and receive environmental information held by public authorities without having to show any kind of interest, right, in so any kind of standing criteria. This also includes information on the state of the environment, factors affecting or likely to affect it, and measures taken or planned to protect it. So basically, public authorities are required to collect and disseminate environmental information proactively, which also includes making information readily available and accessible through various means, including electronic databases, public registers, but also ensuring that the public can easily find and use those information, right? So it's basically all about the availability of the information, transparency of information, and making the public aware. So finally, while public authorities may charge for providing such information, the costs also must be reasonable and not act as a barrier to such an access.
Yes, that absolutely makes sense, as access to information is absolutely crucial because it empowers citizens to be able to make informed decisions where they, are forced to make any decisions. An example, a slightly different example about that in the European Union would be the Green Transition Directive that's been recently proposed and is ongoing in the legislative procedures right now, which really focuses on empowering the consumers to make these informed decisions by obliging the companies to really disclose all the necessary environmental information. And this is because when people know what's going on, they can really hold authorities also accountable. Another example would be if a company is planning to build a factory that could pollute a local river, the community should perhaps have a right to know and to respond appropriately to protect their interests.
Yes, exactly. And so you can see that this trend is currently very much visible within the EU legal structures, as indeed the public awareness, public participation becomes a more and more important aspect. And that also brings us to the second pillar, so the public participation, which basically allows the public to have a say in environmental decision making, right? So we not only are talking about awareness of what's going on within the decisions that are considering environment, but also actually having a direct impact. So what does it mean? It means that before a project that could affect the environment is approved, the public must be consulted and their views must be taken into account. They must be involved very early in the decision-making process, so not ex post after everything is already agreed on. When all the options are open and their input can really influence the outcome. So procedures for public participation must be also very clear. They must be transparent and they must provide timely access to all relevant information. Authorities also must provide adequate notice of opportunities for public participation and allow sufficient time for the public to prepare and participate effectively. What's more, authorities are required to take due account of this public's contribution to their decision. It doesn't mind that they are obliged, well, legally, by such inputs, but they need to take it into account, and they cannot just take a contrary, opposing decision without actually justifying it. So, and in the end, if public participation rights are violated, the public must also have an access to a review procedure before a court of law or another independent and impartial body, so also to hold such authorities accountable. So we can see that this is, well, basically fundamentally about democratizing this whole environmental governance.
Okay, so it seems to me that it's not about just ticking boxes. It's about genuinely considering the views of those affected by environmental decisions. This makes sense as it can lead to better outcomes for both the environment and the community, that in the end is an integral part of proper environmental governance.
Yes, exactly. Obviously, it does not come without challenges. Obviously, all administrative issues are there as well, but that's basically the idea. And that's also what leads us to the third pillar, which is the access to justice. So the most, well, I would even risk a statement, revolutionary ones in the sense of Aarhus Convention. Basically, this ensures that the public can challenge public decisions that have been taken without respecting the right to information, participation, or without proper consideration of environmental laws. Whereas the third one, the last aspect, is, in my opinion, the most important one.
Could you provide some examples of the third pillar in action? How can one challenge a public decision that goes against environmental considerations?
Yeah, sure. So basically, access to justice means that if an individual or NGO believes that an environmental law has been violated, they can go to court to seek redress, right? And this is essential for the enforcement of environmental laws, as it basically holds both public authorities and private entities to account. Of course, well, there is this issue of legal standing, which is a little bit more complicated. In the case of violation of the right of access to information, well, as I told you before, anyone can bring such a claim. In the case of participation rights, only members of the public concerned who have a sufficient interest or whose rights have been affected can do so. It is worth mentioning that NGOs by default meet this criterion of sufficient interests, which is also quite important. And then with regard to breaches of environmental law, well, even though I said it is quite revolutionary, still members of the public have access to justice in accordance with the provisions of national law. So we can see that it might not be harmonized to the extent that we would like it to be.
Well, yes, it does sound like a good start, but is it at all effective?
Yeah, so, well, the answer to this question could be a separate episode in its own right. But it is worth mentioning here that the convention was accompanied by the establishment of the Committee on Compliance with the Convention, which has quite broad powers and, most importantly, the ability to issue binding opinions, which is aimed at, making this enforcement aspect more effective indeed.
I suppose, however, that the access to justice in environmental matters also attracts criticism. What are the most often heard points of criticism? Is any of the three pillars more controversial than the other?
Yes, well, indeed, it needs to be said that it's not all smooth sailing. There are several challenges and criticisms when it comes to access to justice specifically. So the third pillar, which as I mentioned, is a bit is quite distinguished from the other ones. I would say that high costs, lengthy legal processes, and lack of awareness of the public that such rights even exist can basically all hinder the effectiveness of these mechanisms. And indeed, starting with the costs, it is indeed one of the main barriers. Well, we all know that legal proceedings can be very expensive, and not everyone can afford to take their case to court, especially if it does not consider them privately, but they are more of concerned about the environmental issues. So, and this is particularly true in common law systems. In addition, the process can be very intimidating and complex, which can basically, deter people from seeking justice. And obviously, convention does not address it, as it would basically breach the sovereignty of states of ruling over their administrative procedures and other national laws. Well, furthermore, as noted above, while the convention ensures that the states parties provide a legal framework that allows for relatively broad access to justice, it does not fully address the issue of legal standing. So, and this is particularly the case for individuals who do not always have adequate legal standing. They do not always meet adequate legal standing criterions, and for NGOs whose capacity is often limited, especially in the case of foreign entities. So, yeah.
Okay, I now understand why the question of effectiveness could indeed be an episode or two, maybe, on their own, especially as you mentioned, the last part is particularly close to my heart, which is legal standing. How do we even make people able to stand in front of the court when the interest affects everyone? But there is one more question I've got, which is about administrative efficiency. We all know that it often does not really work the way we want it to, and that going through this whole administrative machine in itself can be another obstacle to the goal of ensuring equal access to justice, of not only cost or how complex it is, but even just going through this whole framework.
Yes, exactly. Yes, because as I mentioned, administrative procedures, obviously it's one thing, but we all know that, administrative procedures in reality, not in, legal books, is a completely different thing, right? And that indeed is a relevant argument in this discussion, as the case of access to information, in the case of, for instance, access to information, the inaction of administrative bodies is unfortunately a relatively common phenomenon, as it is the lack of decision, as is the lack of decision based on the merits by administrative courts, right? So basically, instead of sending the decision, instead of giving you a substantive answer why a certain decision was taken, they're basically sending the decision back to the administrative bodies for reconsideration. And I think I don't even have to tell you how this usually ends. But still, I wanted to stress that despite those challenges, in my personal opinion, the EU and signatory countries of Aarhus Convention continue to strive towards improving access to justice in environmental matters. I think it's quite a big milestone in this direction. And I also wanted to say that the European Court of Justice also plays a crucial role in this, especially in interpreting and enforcing EU laws to ensure that environmental protection is upheld across member states, which is quite relevant in the context of interpreting Aarhus regulation as well.
I think we can now move on to the second part of this episode, which will be about protecting the environment through criminal law. Rob, could you introduce us to the topic?
Yep, of course. Let me have a sip of coffee. And we can proceed. Yes, of course. So in this section, we'll look at how the European Union protects the environment through criminal law, right? So environmental crimes are series of offenses that can have devastating effects on the ecosystem and human health. And I don't even have to say that it's vital that these crimes are met with severe legal consequences.
But what exactly is environmental criminal law, Rob?
Yeah, so in essence, it is the use of criminal sanctions to prevent and punish activities that harm the environment, right? Simple as that. These activities can range from illegal waste disposal to, for instance, wildlife trafficking and pollution.
But why is it important?
Yeah, so we first need to, I would like to start with a simple question, right? So why do people commit these crimes in the first place? And the answer is, well, quite simple, but for some maybe not that simple, because it is profitable, right? And even though this answer is very simple, it is also a basis for understanding the whole mechanisms of environmental criminal law. And that's where economics professor Gary Becker points out that criminals basically act as very rational individuals who seek to maximize their utility, right? So their decision-making process is relatively simple and boils down to basic economic calculations, such as calculating potential risks and benefits. And now the benefits usually take the form of the profits they make from illegal activities that, well, in this case, exploit the environment, while the risks may include potential sanctions and the likelihood of detection. Why is it important? Because if we want to achieve the highest standard of environmental protection, we must use the most punitive and enforceable legal mechanisms available to basically maximize the risks for criminals and minimize the profitability of basically exploiting the environment. Yeah.
I assume that considering how we're sitting here and discussing it and how develop the framework, the theoretical framework behind environmental crimes is, that must mean that in the EU, these environmental crimes have reached some considerable level worth of analysis. Are there any statistics that would point us to a conclusion that codification alone does not suffice for elimination of crime, that we need to do more than we've done so far?
Yeah, I think we actually do not realize how big the scale of environmental crime is, not only in the EU alone, but basically worldwide. According to Eurojust, environmental crime is the fourth largest criminal activity in the world and is growing at a rate of between 5 and 7% per year. In the EU alone, costs of environmental crime is estimated to reach almost 16 billion euros annually. Moreover, given the highly international nature of these crimes and the fact that most of the time it involves organized crime groups, the need for international cooperation mechanisms and harmonized legal frameworks is of, well, paramount importance.
Are there any pieces of legislation that are not directly related to environmental protection, but which are indirectly very important for the enforcement and prosecution of environmental crime worldwide? What I mean is there any way to leverage the legal tools that we already have at our disposal?
Yes, there are a few that I could enumerate here, and the examples include, for instance, the 2008 Council framework decision on the fight against organized crime. As I mentioned, the environmental crime often involves organized crime groups, but also anti-money laundering directives and many others, such as the mutual recognition of freezing and confiscation orders. But what is of particular interest to us today is the framework on specifically and directly environmental criminal law. And the cornerstone of the EU's approach to environmental criminal law is the Environmental Crime Directive, adopted in 2008. And basically, this directive sets out a list of serious offenses that member states must treat as criminal offenses. And the aim is therefore to provide a high threshold for this ex ante deterrent element, right? Which will influence the formula of criminals in such a way that it will not be beneficial for them to exploit the environment in order to make a profit.
And could we take a little bit of a closer look at what these criminal offenses mean? What exactly is being criminalized? Do you have any examples, Rob?
Yes, so basically, Environmental Crime Directive covers a range of activities. For example, it includes the illegal discharge of pollutants into the air, water, or soil, but also illegal waste management activities and the unlawful trading of endangered species. These acts are basically criminalized because they pose significant threats to both the environment but also human health. So we also have this individual private interest distinguished here. And it's worth mentioning that the implementation of this directive varies across member states, but the goal is always the same: to provide a strong deterrent against environmental violations. And member states are therefore pressured by this directive to establish effective, proportionate, and dissuasive criminal penalties for the offenses I mentioned earlier. But there is a but, because many scholars, including Professor Michal Faure, who is also professor at the Maastricht University, where we all come from, stress that effective environmental protection can only be achieved through a toolbox approach, so-called toolbox approach. So basically an approach that allows the imposition of, either administrative, civil, and criminal sanctions, depending on the offense in question. And that's important because the Environmental Crime Directive, the 2008 Environmental Crime Directive, does not provide for such a possibility, or at least it does not harmonize member states' legislation in this respect.
And since 2008, there has been nothing new done in this aspect to make it more effective?
Well, luckily, there are changes coming, and because the European Crime Directive finally reached the stage of being amended, and there's actually not even amended, it's going to be changed by the new European Crime Directive of 2023. It is still, I'm saying that it will, because it is still in the process of being implemented, but the final text has been approved. So, and I need to say that it comes in as a minor revolution. And this is the instrument I would like to also look at more closely today.
Does the new proposal address any of the pain points of the 2008 directive?
Yes, luckily, yes. And the first change is the introduction of minimum sanctions that also has been lobbied by a lot of scholars and persons involved in creation of this new ECD. For example, Article 5 sets penalties for natural persons, with some offenses carrying a maximum of 10 years imprisonment if the offense results in the death of a person. So that's also quite important in the sense of this deterrent aspect that we have mentioned. But most importantly, the new ECD has introduced this toolbox approach, which I mentioned previously, by referring to many administrative remedies and including a wide variety of penalties such as fines, obligation to restore the environment, disqualification from exercising a leading position in a company or other legal person, etc. So they also include penalties specifically for legal persons, which in my opinion is also a very good thing that has been introduced, which is provided, for example, in Article 7, such as placing under judicial supervision, closure of the establishment, judicial winding up, etc. Right? Article 10 also allows for the freezing and confiscation of assets, so we can see the interrelation with other legislative products of the EU. And finally, the new ECD also introduced a data collection obligation for all member states, requiring them to produce and make available statistical data on the number of offenses, dismissed court cases, and prosecutions. So we can see again, enforcement, deterrence, those are once again main elements of the new ECD, of the improvements of the ECD. But what is a really big revolution is that the new ECD introduces so-called autonomous environmental crimes.
Autonomous environmental crimes. What do you mean by that?
Yeah, so you see, I have deliberately not mentioned the link and dependence of criminal and administrative law because that is a subject for a separate discussion. But but it is quite important here, and let me maybe give you an example why it is important to recognize autonomous crimes. So imagine a situation in which, well, for example, a local government, right, grants a permit to a company to set up an industry that significantly pollutes the local area. Let's also say that this permit should never have been granted, but for some dubious, shady reasons, maybe such as corruption, it was. And until now, if someone wanted to hold the company responsible for such pollution, their hands were tied because the company could use its so-called permit shield and claim that everything was legal because the permit was issued by the administrative authority, right? So you cannot do anything. We are all acting legally. Now, we all know that in practice, it is often impossible to prove corruption or bribery. So in such situations, cases could go on for years without anyone being held accountable. And obviously, the pollution and often irreversible damage to environment and human life continued uninterrupted. And now, the autonomous environmental offenses lead to criminal liability even if there is a permit, a legal permit, or other type of authorization. Obviously, as you probably assume or even want to ask a question about it, the threshold in such situation is very high, since the offense must include the element of a manifest violation of relevant substantive legal requirements as provided for in Article 8 of the new ECD. So basically, this refers to long-lasting and widespread environmental damage for Article 8 to be even triggered. But despite this high threshold, I still think it is quite revolutionary and can now really change the way environmental crime is enforced in the EU.
I presume that many of the crimes must be cross-border in nature and complex. How does the EU deal with that? Do the cross-border enforcement agencies such as Europol and Eurojust play any role?
Yes, I'm glad that you asked it because indeed, enforcement is still one of the challenges due to the complexity and cross-border nature, as you mentioned, of many environmental crimes. And this is why EU agencies like Europol or Eurojust are indeed very important players because they are coordinating efforts across member states to tackle environmental crimes more effectively. And indeed, I would like even to devote part of our discussion also to them. So, as you mentioned, environmental crime often involves organized crime groups and can span multiple countries, right? And Europol and Eurojust are basically EU agencies that work together to facilitate cross-border investigations and prosecutions. For instance, we have seen significant successes in operation targeting illegal waste, trafficking networks, where cooperation between member states was, undisputably crucial. And so what is, maybe also give you some background to what those agencies are. So Europol, starting with Europol. Europol is a European Union agency for law enforcement cooperation. It basically supports member states in their fight against serious international crime, including environmental crime. Well, you probably have heard about Interpol. I think the easiest explanation is that Europol is a very similar agency, but at the scale of the EU specifically. Europol's role is crucial in tackling cross-border environmental crimes because, for instance, in illegal waste trafficking, it often involves those multiple countries, right? Where we have the origin, we have the transit and destination countries. And basically, they help to coordinate those investigations on operations.
Okay. I do understand, I think, why Europol is important, especially if we talk about criminal law, and then the engagement of Europol absolutely makes sense. But I do have a question about Eurojust. So this is about the judicial cooperation. Why would Eurojust be important for environmental criminal law?
Yes, so the answer is relatively simple. Eurojust basically supplements Europol by complements Europol by focusing on judicial cooperation, right? So when Europol coordinates the investigation, it leads to a prosecution, right? For example, to arresting certain individuals who are responsible for serious environmental crimes. Then Eurojust helps coordinating the legal proceedings across different jurisdictions, ensuring that the cases are prosecuted effectively, even when they span multiple countries, including the country of origin of the individual, country where the crime was committed, etc., etc. So it's about overcoming legal and procedural differences between member states as well, right? Because we still have them, as we know, especially within the criminal law aspect, which is not harmonized to a significant extent at the EU level. Yes, so that's basically it.
Okay, I see. Well, that indeed makes sense. Europol, Eurojust, so that area of further law enforcement. But then my question would again be the annoying question of effectiveness. Do we not need, for example, Frontex to bring even the criminals, quote unquote, criminals, in front of these courts? So Europol and Eurojust without capturing them first is relatively useless, no?
Yes, and actually, thanks for asking this question, because I focused only on Europol and Eurojust, but the credit needs to be paid also to many other bodies that play a crucial role in investigating and prosecuting environmental crime in the EU, such as, well, as you mentioned, Frontex, which is the European Border and Coast Guard Agency, stationed right now in Warsaw, but also, for example, the European Environment Agency and many networks. That's also important. We don't have too much time to talk about it, but there are also many networks that really help coordinating specific types of action, which is also very important for the practice itself and for the practitioners of criminal law, environmental criminal law.
Could you give us a real-world example illustrating how the agencies work together?
Yes, I actually prepared one. It's the Operation Retrovirus, which was a joint effort by Europol, Frontex, Interpol, and other agencies and networks to combat the illegal trafficking of waste in EU countries, but not only. That's why Interpol, for example, was mentioned, enumerated here. So to give a background, at the beginning of the COVID-19 pandemic, Europol foresaw a global problem with the illegal processing and disposal of sanitary waste. As we all know, it was a big thing, especially at the beginning of the pandemic. So in response, Operation Retrovirus was launched in coordination with Anti-Crime-Net, which is one of those networks that I mentioned before. And the aim of this operation, which ran from, well, March to November 2020, was the early detection of illegal collection, management, transport, and disposal of sanitary waste. So Europol's role was basically that they designed, coordinated, and supported the operation by providing analytical and operational support and coordination, while also facilitating instant communication between the participating authorities. They also supported the investigators with the extraction of encrypted data from mobile devices and operational analysis in real time during the action days. Frontex, on the other hand, contributed to the operation by providing a situation assessment and comprehensive training on the detection of sanitary waste and medical devices. They also provided tests and sanitary products to staff deployed at border crossing points, in particular to member states' customs and police authorities. So overall, because I could talk about it much more, but overall the operation was coordinated by Europol and many organizations, including also Commission's DG Environment, Impel, Frontex, as I mentioned. In general, a total of 30 countries, both EU and non-EU, participated in this large-scale operation. So I think it illustrates quite well how international such crimes can be. And during the operation, the authorities carried out around 280,000 inspections, resulting in 102 arrests. In addition, 819 organizations and individuals were subject to administrative sanctions for some infringements, basically. There were 819 seizures, including 22 consignments of waste and assets worth, almost €1 million. I think it was 800,000 euro. I think that illustrates how important it is, what is the scale of such activities, and how crucial it is for us to have those harmonized mechanisms, enforcement mechanisms that allow for efficient prosecution and efficient investigations of such crimes. Now I hope you have a bit of a better idea of the EU's integration of both access to justice but also environmental criminal law. That, well, again, I will repeat myself, but in my opinion, represents quite a robust strategy to safeguard the environment. And if I were to say what are the main key takeaways of our today's podcast and discussion, I would say basically it's all about empowering citizens, right? Strengthening legal frameworks and fostering international cooperation, which are central to ensuring that environmental justice and combating environmental crime, takes place and creates a promising and sustainable future for us. If we then connect it with our future element that we discuss usually on our podcasts. So I don't know if you have anything to add, but thank you for this discussion. And yes, I guess we will talk with each other soon during another episode that we plan to create. And yeah, thanks for being here. And I think that's it. So yeah, thank you and see you.
Yeah, thank you, Rob, for that very insightful dive. Thank you, Hanna, for being here. You have surprised me quite a few times today. And thank you to y'all listening on the other side of the headphones, I guess. And I see you next time.